Welcome back to House to Home. This is a podcast produced by Family Policy Alliance Foundation. My name is Grace Youngson, and as always, I'm joined by my co-host, Joseph Kohm. And today we're going to be covering some recent news. Unfortunately, late Sunday night, California Governor Gavin Newsom signed Assembly Bill 495 into law. This law represents the culmination of a generational effort by the California government to destroy the nuclear family. On today's show, we're going to analyze and lament the destruction by tracing that effort over the course of the last 3 decades. But we're going to begin the show today with a very special guest who is joining us for the first few minutes just to talk about AB 495. Jonathan Keller is the president of California Family Council, the state family policy council in California. And Jonathan and his team have done heroic work in opposing this awful bill. And so we're honored to have him on for a few minutes to talk about this. Welcome, Jonathan, and thank you for being here.
Grace, Joseph, thank you so much for having me. It's an honor to be with you.
Great to have you on, Jonathan. And I've noticed in our work that sometimes state legislation, it has a lot of bite to us who work in this day to day. But for our audience who blessedly usually don't have to think about these things, it can seem a little not boring, but just not dangerous. The problem is AB 495 really is quite dangerous, sadly. Yeah. And so that's why the first thing I want to get you to talk about just while you're here for our audience is, what does the bill, Assembly Bill 495, actually do? Like, what is its effect? How does it function?
Well, Joseph, thank you for that. And yeah, I want to give a little bit of a 30,000-foot overview and say that in California, like a lot of blue states, we are constantly playing whack-a-mole. There are dozens of bills every year that we are really deeply concerned about. In California, there's thousands of bills that we monitor every year, but really a few dozen end up being those that are of most particular concern. AB 495 is certainly one of those. And I want to start off by being charitable and saying, if we have any listeners who are from California, or if we have listeners that are maybe from even red states, but they are more on the progressive Democrat side of the spectrum, I don't ever want us to be accused of misstating or being uncharitable in the way we talk about these bills. So let me give you what I think is the very best rationale for this bill and why I think, sadly, it is so sorely misguided. So, number one, there is a legitimate concern that I think everybody would acknowledge, that you don't want, as often as possible, you do not want to have children separated from their parents. You don't want to have children cared for by the state when there are qualified family members or close friends and relations who can step in and take care of them. This would apply whether or not parents are in a car accident, whether they are deployed overseas for military operations, or whether tragically they are involved in some sort of a crime. And that is the way that this bill is being sold. They are saying, look, and especially in some of the revised language, they were saying, look, whether they are being detained, deported, or deployed. That's the phrase that you now have started to hear them try to use as a way to market and sell this legislation. They're saying, look, all children deserve to be taken care of by either their next of kin or by a qualified designated person, which is absolutely true. If someone is being deployed, of course, you don't want those children to go into foster care. If someone is being taken care of while their parent is in the hospital, then yes, you would want ideally for a sister, a brother, an uncle, an aunt, grandparents to be able to take care of them. And I would even say that when it comes to the issue of deportations, we've seen President Trump do a lot of work in the last 9 months to really help secure our border after some of the disastrous policies of not just the Biden administration, but also the Obama administration. We have seen, sadly, in some cases, children who are essentially not being actually orphaned, but they are being legally or bureaucratically separated from their parents. And in some cases, these kids are American citizens. They were born here in the United States, but one or both of their parents broke the law when they came here. They illegally stayed, and now they are facing the legal and justifiable consequences of those actions. The best case for this legislation is that legislators in California want parents to be able to choose who those children go to. They don't want children of illegal immigrant parents to automatically go into the foster care system. They don't want them to automatically have a severance of parental rights and to be adopted out to someone. All of those are totally legitimate concerns, and I think those are totally legitimate things that most Republicans, most conservatives, especially Christians, would agree with. We think that parental rights are actually very important. But sadly, that is actually why we oppose this legislation and why, despite its very best intentions, it is so completely misguided and dangerous. Essentially what this is doing, AB495, plays upon an existing procedure, an existing document called a caretaker's authorization affidavit. And essentially what this does is it dramatically expands and opens the floodgates for who can be considered a justified caregiver. Now, the original version of this was even more expansive. It actually specifically referred to people who had a so-called mentoring relationship with a child. It also explicitly stated in the original version that did not pass, thankfully, the one before it was amended, we were able to knock it down. The original version had explicitly said that it did not require a parent's signature. It said it not once, but multiple times, saying there was no parental signature needed. Now, that's not the final version that Governor Newsom signed, so I will say I am grateful that the original version was not signed. But that being said, Joseph, as we know, so often a lot of these bills end up being kind of a bait and switch. We see what is marketed, and if you go to the governor's own website, you see the way he's talked about this. They are claiming that this is all about protecting parental rights. It's preventing families from being separated. It's giving more authority and opportunity for parents. But the reality is, even though they took out the phrase, no parental signature is required, they very cleverly, Joseph, did not put in the phrase parental signatures are required. So in the absence of that requirement, in the absence of that explicit declaration, guess what? There is still no parental signature that is required. It is now something where you are going to have both the state attorney general and the state education secretary offering guidance to these individual school districts and to others saying, I know it doesn't have a signature, but you have to accept this anyway. It also, even though it removed the phrase that says someone who's in a mentoring relationship with the child can take custody, or I should say, take authority and control over. It's not technical legal custody, which is one of the other very clever weasel words that they try to use to say, no, this isn't affecting custody. Well, okay, but it is affecting authority, authorization, medical decisions, educational decisions.
All the things that would normally only be given over to a custodian. Like, that's the things that having custody gives you, is those decision-making points, correct?
That's right. And even though it is very clear that this does not now apply, they took out the language that says it specifically authorizes someone in a mentoring relationship. The definition of someone who can be able to take authority of a child now extends to the 5th degree of kinship. That's the actual language that they use. Yeah, so that was the eye roll, Joseph, was my response exactly as well. The idea that this would not just be someone who is a sister, a brother, an uncle, an aunt, but multiple layers of removal. Again, let me give you your best case scenario. I can understand theoretical best case scenario if you have a large family group who comes here to California, let's say from Mexico or from Central or South America. You may not have verifiable family trees that shows, no, this is actually my second cousin's daughter. So you may want to be able to say, well, this is who this is. Here's the problem. By not including any sort of verification, again, no parental signature, no notarization is needed for this document. Frankly, it doesn't matter who the person says they are. If they can make a plausible claim that this is my relation and connection, anybody can fraudulently or surreptitiously kind of say, yeah, this is who I am, this is how I know this person. And it would be very easy for a child, if they're being groomed or being coached by an older adult who's trying to help them with either puberty blockers or cross-sex hormones or other sorts of processes. They're wanting to switch them to a different school. They're wanting to do all sorts of other authorizations that would be enabled by this affidavit. It'd be very easy for someone to say, well, yeah, that's why you haven't heard of me. Okay, yeah, that's why I'm not on this trusted contacts list. But this is my so-called relationship with the child and with their family. So in many ways, Joseph, we are deeply, deeply concerned. We remain incredibly troubled by the fact that the current version of this was bad enough. The expanded version of this is maybe a touch better than the original version before we held our large rally with Pastor Jack Hibbs at the Capitol back on August 19th. But this remains if not a 5-alarm fire, at least a 3 or 4 alarm fire for parents in the state of California. And we really urge people to take steps actively to protect themselves and their families.
Yeah, and we're going to get into the steps you're going to urge people to take. Jonathan, before we do that, I want to just ask you one or two clarifying questions here. Then Grace is going to ask you about your efforts to oppose this bill with CFC and your broader coalition. But just first, that summation was so excellent. And the reason I couldn't help but roll my eyes when you're describing this kinship relationship is that it's clearly just a legal farce. It's a fiction to cover the actual goal. It seems like and we see this a lot in the policy world, as you know, Jonathan, early versions of proposed legislation will be much more explicit about the legislator's intention behind proposing the legislation than the final versions. Basically, they say the quiet part out loud early on for whatever reason. Maybe it's just poor drafting. Maybe you're just trying to move the bill. And the final bill just omits all the stuff without really blunting its edge. And that's why my eye roll is tragicomedic. It's the only way to respond to this. I feel like you're letting people who are more removed than Frodo was from Pippin, my second cousin once removed on his mother's side. That's closer than what's allowed in this bill. Right. And that's why I think that's one of the only ways to respond is this is hilariously tragic. So you mentioned the main method of doing this, the bill authorizes is this Caregivers Authorization Act. And in the CFC press release, you guys do a great job linking to an example of what that looks like. So people don't have to believe FPA. They don't have to believe CFC. They can just go to the link in your website that's on the bill, and that's the form. So for our listeners, though, before Grace asks you about the coalition effort, just tell us what information is exactly required to be filled in on the caregivers authorization list. Like, how easy is it to fill this out and get this control over a child?
Well, part of the other concern about this is that, as I understand it, from talking to attorneys and other people, there is not a single authorized version that is the one single type that you have to fill out. It is more describing, I believe, a type of document. It is not describing a singular document itself. Like, for example, anybody who files taxes or gets paid, you know that you have certain forms that are IRS standard forms that are federally recognized, or they might be a state recognized form. And they're so specific that they have an actual number. It is a W-2 form. It is a 1099 form. They have a very explicit number. They don't just say, an employment verification document. It's an I-9. It's something that is very clearly delineated, and there is one form for every employer, for every employee. Everybody knows what it is, and it is going to be the same regardless of what state you're in, what county you're in, who you're working for, etc. In this case, as we've understood it, there is not a singular form that is going to be put out. It is essentially going to allow individual school districts to accept a form as it's written in. And the big concern about this, Joseph, is I think there's going to be a lot of lack of standardization over this. And that, I think, is going to be a huge problem. Best case scenario that you see people, I don't know, Joseph or Grace, if this was you guys when you were growing up, but my parents, whenever we would go stay with friends or we would stay with family, my mom was always a little bit paranoid, and she would write out these handwritten authorizations. I authorize so-and-so, Mike and Kathy Crumley, to take care of my kids and provide any medical care or, any dental services or whatever it is in case my child, falls down, breaks their arm, chips a tooth, need to go to the emergency room. Here it's signed by me and their dad. That is basically, I think, almost the level of authorization that a lot of these are going to be treated as. It's something that it will be back then, I mean, my parents didn't have a home printer, so they were just, filling out a piece of paper, maybe on a sheet of paper or, notebook paper, 3-ring binder, a yellow pad, whatever it was, and saying, yeah, here's the document that is authorized. Now, I think now people will be able to come up with something that is a facsimile of that type of a form that looks much more official and authorized. But beyond having the name of the child, the name or the address of the family, and then the name of the person who is picking up the child, there's really not a whole lot more verification that is going to need to happen. But again, in some of the original verification documents that have talked about this, because, Joseph, this is another horrible distortion that we see so often, because the primary constituency for this type of a document, at least in the best case scenario, is a family of someone who is in the country illegally. This means that it is incumbent upon them to actually require the least amount of verification and information possible, because they know that if they provide additional information, whether it's addresses, whether it's extended family, whether it's date of birth, etc., in some cases, there's a decent chance that the person who may be trying to pick up these children from school may themselves have questionable legality in terms of their immigration status. And as a result, it's incumbent to say, well, we can't create a barrier to entry for these families and these individuals by requiring citizenship documents or by requiring a birth certificate or, in some cases, even a driver's license. So that's part of the other reason why not only is a signature not required, but there is no real verification that is going to, I think, be explicitly required by this statute. And that's the huge concern about this. This really would, despite the best intentions, I think we can all see that in almost any other circumstance, if you were trying to lower the thresholds for allowing someone to pick up a child, it would be incredibly dangerous. And I think not just most parents, but most legislators, most other people would agree this is a bad situation. But because of this particular carve-out, Joseph, I know we've talked for a long time in legal jurisprudence about the abortion distortion. Well, now we're starting to see an immigration distortion. And anything that we can do to kind of serve the needs or the desires of I don't even want to call it a pro-immigrant community. I want to say the pro-illegal immigration community or the anti-immigration enforcement community, that is really going to have a disastrous domino effect for all families, whether you are a 5-generation resident or you've been here for 5 weeks.
Yeah. Well said, Jonathan. We want to know more about your coalition efforts to oppose this bill. Thank you for summarizing that last bit. I wanted to ask about how the Caregiving Act works. I think that communicates the severity of this. So, Grace, what do we want to say about the coalition effort to oppose this? We were mildly involved in, but mainly CFC was a much bigger player, obviously.
Yeah, well, first of all, I would just comment and say, how shocking this all is. Thank you for explaining it, Jonathan. I think just remembering that we're literally dealing with children's lives here and that this is being kind of thrown about by the California government is really concerning. But yes, we would love to know, what are you guys at California Family Council doing next to oppose the implementation of this? How can people get involved? And yeah, we would love to know more about that.
Well, I would encourage everybody. I know one thing that immediately happens whenever you have an aftermath of a bad bill like this that not only passes but is signed, people immediately kind of panic. They wonder, what's the next step? Now that we know how bad things are going to be again in California, is there anything we can do? And there's a multiple faceted reality to this. Once a law is passed in California, the chances of directly overturning it, at least legislatively or through a referendum, those are extremely slim. It's obviously entirely possible that we could see in the future a new governor elected. You could see new legislators elected. You could see something passed in the future to completely repeal this. I think that's highly unlikely, and I don't think we should be pinning our hopes on that. I do think, tragically, that it's possible if we see a few cases of children who are harmed or children who are essentially more or less legally kidnapped as a result of this. You could see an outcry within the next few years to create a fix for this legislation. Unfortunately, that's going to mean that you would have to have some cases of children or families that are hurt. And I think that is at least highly possible, if not likely. But the other avenues that we can take, there's at least two other avenues that I would encourage people to do. Number one, CFC is going to be working with all of our legal partners, both state and national legal organizations, to look at possible lawsuits or challenges, talking about the fact that this is completely wrong, that there's a clear Supreme Court precedent through multiple cases over multiple decades that parents have the fundamental right to direct the care and upbringing of their children. And by creating this massive loophole for individuals to come in and potentially usurp those rights, it represents an infringement on parental sovereignty and something that the state of California is not able to do. You cannot allow parents to sign away their rights without even signing away their rights. The fact, again, that there's no signature required would seem to be completely antithetical to so much Supreme Court jurisprudence in recent history. Especially, for example, one of the great cases that we saw just earlier this year, the Mahmoud v. Taylor case, the fact that you have to have parental rights to direct the education on specific subjects with specific books, to say, well, yeah, but if someone comes and presents a form without your signature, they can completely change where your child is enrolled in school. They can completely change what type of medical care your child is going to get. That would seem to be, I don't know, Joseph, maybe a violation of at least the spirit of that opinion.
It at least sets up a conflict between the two. I'm not a lawyer in California, but I do know about the Supreme Court jurisprudence you referenced, which is entirely true. Parental rights are considered a fundamental right under the U.S. Constitution, and that includes medical decisions, education decisions. So that's why, not trying to take back to my eye roll again, but like, this is why this is such a joke about custody. Why I interjected back there is because this is neutering custody for parents. Like, they're not directly saying, well, we're getting rid of the idea of parental custody. We're just getting rid of the bite to it, like the edge to it, which is the whole point of parental custody. At least one of the whole points is only I, as the parent, can decide which school my kid goes to, what medical treatments they receive or don't receive. And if anyone can do that, then what is the point of custody in the state of California? So that's why I think at the very least, it sets up a conflict between those two doctrines, California versus the historic, traditional, constitutional understanding of parental rights in America and what custody actually means. So glad to know you guys are exploring that, Jonathan, with your state partners. I would just encourage our audience to pray for you, pray for that coalition, pray for families in California that kids are kept safe. And just, Jonathan, if people really do want to follow this and support you all and pay attention to your work going forward for maybe 495, tell them your website, where they can do that, and where they can follow you at social media.
Absolutely. Well, our website, very simply, californiafamily.org, and you can find us on most, if not all, of the social media channels. We're not technically on TikTok, but if we might finally get on there if this purported sale goes through. I was not thrilled about doing anything with them as long as they're Chinese owned, but we are very active on Instagram, on Facebook, on Twitter/X. We've got a lot of YouTube videos up there as well. And Joseph, that's the thing, Grace, I want to also say this is kind of the closing. In addition to the legal challenges, there's one other way that we will encourage people to be active and engaged is trying to take your children out of the public school system in the state of California. I think that is honestly kind of the lowest common denominator that I would respectfully urge any parent in the state of California take a really long, hard look at whether or not there's any way you and your family can make the decision to get your kids out of public school. I know that's not an option for everybody. I know we have people that are probably listening that are either single moms or single dads. Maybe they've been widowed. Maybe there just isn't a practical effort. There's no family nearby. They can't get their kids out of public school. I understand that. I don't want to heap guilt on you or heap fear on you. But for anyone where you have a practical option of either homeschooling, private schooling, Christian school, I would beg you, please look and see if there is some way that you can take your children out of the current regime that is run by Sacramento run by State Superintendent Tony Thurmond, run by Attorney General Rob Bonta, and run ultimately by Gavin Newsom. These people do not have the best interests of your family, of your children, and of your values at heart. And I think we can look at that both through the cavalier way with which this bill AB495 was passed, but also, Joseph, I know you're going to talk about it later in the show, so many other examples over the last several years of California completely not just disregarding, but actually attacking parental rights and Christian parents and families. So I would urge you, follow all of those places for us online, but also look at ways that you can take those practical steps to shield your children from some of these really malign influences.
That's a great call to action, Jonathan, which we will reiterate before the end of the show. And we will also include links to both the California Family website and your social media in our show notes and our episode notes for this. So, Jonathan, thank you for giving us so much of your time this morning. We know you're a busy guy responding to this, the time of recording, not even 48 hours after the signing of AB 495. So thank you for joining us. God bless you and your team. We will see you again soon.
Sounds good. Grace, Joseph, God bless. Talk to you soon.
Imagine your child, confused, isolated, hurting. And instead of help, she's offered hormones. Instead of love, he's handed a scalpel. This is not care. This is not compassion. This is experimentation. Right now in America, children struggling with their identity are being pushed down a one-way path. Puberty blockers, cross-sex hormones, irreversible surgeries. These procedures cause sterility, loss of sexual function, permanent voice changes, heart issues, and scars that don't just stay on the body. In many states, these drastic medical interventions can happen without parental consent, or even knowledge. Once it's done, there's no going back. But hope is rising. Across the nation, people are saying, enough. Help Not Harm laws have passed in 25 states, protecting children from irreversible harm and ensuring they receive true, compassionate care. Real help means real counseling, real support, real healing. 80 to 95% of children struggling with their identity will reconcile with their biological sex if left unmedicated and unharmed. This movement is growing, and with your support, we can protect every child in America from dangerous ideology and irreversible procedures. We're fighting in every state. We're working with Congress, and now with federal momentum on our side, it's time to take this to the next level. Your gift can stop a child from being harmed. Your support fuels the laws, the lawsuits, the lobbying, and the healing. Give today, give generously, because kids need help, not harm. Welcome back, everyone. We are going to give you an overview, as mentioned when we were having a conversation with Jonathan, of the history of California's war against families, which is pretty dramatic. When Joseph sent me the show notes for this, I was aware of some of these bills, not all of them, but really it truly is a war. And so, Joseph, could you just outline some of those bills that have passed over the past few decades and what that means for the state of California as it relates to family values?
Yes, Grace, I can do that. And we just want to give a very broad overview for our audience, but we want you to receive from this very clear, we think, recent historical effort by multiple generations of California legislators and elected officials to erode all the legal and governmental protections for the nuclear family. AB 495 is not out of the ordinary, unfortunately. It is, as we described earlier in the episode, the mountaintop of a long and multi-generational effort to attack the nuclear family. So I did some research, not as much in depth as I would like, but we have a pretty good overarching view here, 30,000-foot view, as Jonathan would say, about this effort. I went back at least to 2011. In that year was signed into law Senate Bill 48, which was called the FAIR Act, and FAIR stood for Fair, Accurate, Inclusive, and Respectful Education. But what it required was the inclusion of the contributions of LGBT people in K through 12 social studies and the history curriculum. And so Jonathan alluded essentially to Mahmoud v. Taylor. This is that. There's no way to opt out of that. It had to subject kids in the public school to that against parental wishes. Now, thanks to Mahmoud, parents could probably ask for an opt-out from that, but there'd be a fight over it because California, as you can see, back in 2011, they were talking about this. I mean, LGBT people, most people didn't even know what T was back in 2011. So that was 14 years ago, at least, that this effort started. Then you get on to Senate Bill 1172, a ban on conversion therapy for minors, which you've heard us talk a lot about on the show recently, from the Childs versus Salazar oral arguments the first week of October to our episode with Elizabeth Wanning from Change Movement. They were one of the first states to pass that back in 2012. The next year, 2013, Assembly Bill 1266 or 1266 required that schools permit students to participate in sex-segregated programs and use safe spaces relegated to single sex in accordance with their gender identity. And this was back in, like I said, 2013. They were allowing kids to do this. So, like I said, even that far back, I don't think most people knew what transgenderism was. All the way back then, California schools were once again ahead of the curve nationwide. Schools being forced to allow students to play in activities like sports or clubs, and to use sex-segregated facilities in accordance with their gender identity, not their biological sex. Then in 2015, you have Senate Bill 277, which eliminated personal belief exemptions for childhood vaccines. So there's been a lot of conversation about that in the recent years, which is why I've included it in this list. Even Christians can and do disagree very reasonably on vaccines. But I don't think anyone disagrees that it should be a parent's choice for what vaccines their kids do and don't receive. California eliminated religious exemptions for that in 2015. In 2018, Assembly Bill 2119 or 2119 required schools to keep a student's sexual orientation, gender identity, or gender expression confidential from parents upon student request. I can remember this one. I was not yet working for FPA at the time. Neither of us were, Grace. But I remember this one because it was once again ahead of the curve. California was one of, if not the first states to mandate statewide that schools could not disclose a child's gender identity to their parents if the child asked them not to. Now this has become a worldwide topic of conversation, and for good reason. But this was back in 2018. We hadn't even hit the pandemic yet. That's when most other states started passing a law like this. Let's see. I want to also mention SB 107 because this one was one of the first bills I really worked on in my capacity at FPA, Grace. This was signed into law in 2022. This was one of the first of what FPA has messaged on since then. At that time, we opposed this bill as a kidnapping bill for transgender procedures. What it allows is if a child from a state that prohibits transgender procedures, i.e. a state with a help not harm law from FPA, if a child from one of those states can make it to California, get into a court hearing in their family court system, the court will allow them to stay and take temporary jurisdiction over them so that they can receive those gender transition procedures in California. This was shocking at the time, especially because there were and still are multiple ongoing lawsuits between two parents, where essentially one parent kidnapped a child from a state like Texas, took them to California, claimed legal sanctuary in their family courts, and the adult back in the help not harm state, who disagreed with the child transitioning, had no more say over that child's medical decisions. This was shocking. Like I said, litigation still ongoing about this. But multiple states have either enacted that or made it part of their governor's office policy since then, including Colorado, New Jersey, Washington, Oregon, I believe. These kidnapping laws that we called them, an erosion of parental rights. SB 107 in 2022 was one of the very first. Then in 2022 also, that was a bad year for California, was AB 2223, which was a bill that basically legalized infanticide after birth. So it was marketed as an abortion rights bill. But basically, the way it worked in effect is if someone gave birth to a child, within the first month of the child's life, what they call the postpartum or postnatal period, the bill says very cleverly that the state will not prosecute the parents for what it calls fetal demise, which is another medical term of art. But like that, postnatal and postpartum are also medical terms of art. And what they mean essentially is within the first month of a child's life outside of the womb. And so in effect, what the bill means is the state will not prosecute parents if their child dies during that period.
I remember that bill.
I want to ask you that about this, Grace. Yeah, tell me what you remember about that time.
Yes, I remember when that came out, and I remember just being completely shocked because, there's always this argument when it comes to the abortion issue that it's like, oh, it's not a baby, and it's like, this is so clear that, it is a baby from conception. It's so clear. Even at 8-9 weeks, you can literally see the fully formed human being in the womb. But it's such another step to actually kill a baby outside of the womb. And to me, if that is not an attack on family, I don't know what else is. And so, yeah, that one definitely really stuck out to me. I think it's crazy. And it's interesting because I feel like sometimes with some of these bills, I remember at the time when that was passed, it was all over the news. There was, as there should be, uproar about it. Now that a few years have gone by, it's kind of like it doesn't exist anymore. And I think that in line with that, just a call to our audience, don't allow yourselves to become complacent. Like when you hear of things like this bill AB495 that's just gone through, it's easy to emotionally get, oh my goodness, in the moment, and then let some time go by and actually not keep taking action. But join us, join CFC, and continue to take action because the fight is still going. So but that bill's crazy.
Yeah, you can see how I included it in this list, Grace, because of how shocking it was at the time, how much we opposed it, and how much to this day, this is why we wanted to linger on it in the show. To this day, you and I tell people about this bill, and they often just don't believe us at face value. And I don't blame them, frankly. I don't take that personally. I wouldn't want to believe that this kind of law was possible in the United States of America in 2025. I don't want to believe it, but I have no choice. I have the text in front of me. This is what it says. And at the time, this was the new wave, boldest, furthest most point of the hashtag Shout Your Abortion movement. At the time, Virginia was governed by Ralph Northam. He was our governor here, and I live here in Virginia. And this was his stated policy. Now, he said it in a very, very gentle, very smooth way. He said, because he was a physician, he said, if I were delivering a baby that the parents were unsure if they wanted to keep, we would deliver the baby, we would make it comfortable, he said, and then we would make a decision. It was sickening. This is one of the many things that allowed Governor Glenn Youngkin to win the next election in Virginia. But Virginia is still poised to do this. There are mechanisms by which Virginia could pull this off, and they want to, and we'll talk about that in a future episode. But I've included it in this list because of how shocking it is and how it directly undermines the family, not just the rights of that child, but the obligations of parents. And then following that bill in 2022, there were just a couple more bills that continued to shore up this notion that children should be able to live fully within their chosen gender identity without any parental knowledge or consent, that schools and the government should partner with those children against their parents not to deceive them in this way, including AB 223, the Transgender Youth Privacy Act, signed in 2023. That required when a minor petitions the state to have their name changed on their license, that parents not be notified of that. It was one of several bills that have shored this up. Now you have AB 495, and in the spirit of this show, Jonathan gave us the best case scenario, tried to put that bill in the best light, which we always do try to do here. But I do think, Grace, we might just want to talk very briefly about the worst case scenarios with this bill. And one of those would be on the gender issues. For example, if a child wanted to transition and their parents didn't want them to, well, maybe they could find a friendly adult who would take them to Planned Parenthood to get cross-sex hormones, fill out one of these caregiver authorization acts, and then wave it in front of the Planned Parenthood employee. Now the child's on cross-sex hormones and the parents are none the wiser.
It's crazy. It's absolutely crazy.
And that's not even including abortion possibilities too. Grace, we've worked on this issue for a while at FPA, but the notion that parents should have to consent to their underage child, if they want an abortion, getting one. This obviously, California removed that requirement explicitly at law a long time ago, but this bill makes it explicit. Similarly, a friendly adult could take a child to Planned Parenthood to get an abortion. Waive this Caregivers Authorization Act in front of the Planned Parenthood receptionist, and the child will be in the abortion room in 10 minutes. It's just deeply tragic, and I wish we didn't have to cover it, but we wanted to give our audience an unvarnished look at just how dire this situation is.
Yeah, totally. And, I was thinking as we were going through this episode, yes, I agree with what you're saying. We want to give the audience a look at how dire this is. Also, on the other hand, we want to encourage you that we are working to fight these kinds of things, and we are seeing success across the nation. California is a little bit of a tough spot right now, but we want to encourage you as well that, I think that there is a correct response to this. And first of all, there's that song, worship song, and there's a line which says, "Lord, break my heart for what breaks yours." And I often think about that, especially when I hear of sad issues like this. I want to take a moment to allow God to break my heart about that. But then we also have to get up and do something about it. We can't stay in the sadness of that. We can't stay in the desperation and the hopelessness. We have to say, okay, I'm going to use this sadness, but then the resulting compassion that comes with that. The Bible always talks about Jesus being moved with compassion. Jesus didn't just take pity on people and be like, "Oh, I'm so sorry, that's horrible," and then move on. He felt their pain, but he was moved to do something. And that's really what we're all about here at FPA. California Family Council is doing something. And so, Joseph, I know we mentioned a little bit earlier about, how people can get involved, but would you share with them a bit more about our website, CFC's resources, and just encourage our audience that they can make an impact?
I appreciate the positive take there, Grace, because it is true. We just had Jonathan on. The situation looks dire for families in California, but how great that an outpost of biblical truth and family values like California Family Council is there in Sacramento, holding the line as best they can, making God's voice and our voice heard there in the state capital. And they're not the only one. We have many allied organizations there, including Exodus Cry, who we've had on the show talking about their anti-trafficking work, A21 as well, both in Southern California. There are serious outposts of biblical truth and pro-family values there. California Family Council is just the one that we are officially partners with at FPA, along with our 39 other state family policy councils. And so we just encourage you, if you care about these things, follow us at FPA, follow California Family Council, particularly if you're a California resident listening. Please follow CFC in their work. You've heard Jonathan's colleague Sophia Laurie come on House to Home multiple times. This is the kind of work that they are doing. So it's californiafamily.org. For our website, it's familypolicyalliance.com or FPAF.com. And you can follow us both on all the social media platforms except TikTok. Maybe we'll get on there eventually. But for now, we're on Facebook, X, and Instagram. We will link to both our websites and to our social media accounts in the show notes here. And we will finally also equip you in the show notes with California Family Council's very thorough, very excellent press release breaking down AB495 and its dangers. So you can make your voice heard with us, through us, support us however you can or feel led. And then we'll just ask you, please pray for us. Prayer makes a difference. I have been in the California State House advocating for pro-family bills when I knew people were praying for me. And I felt the Holy Spirit within me that stirring, that it was making a difference, people's prayers. So that's what I would encourage people to do. Anything else, Grace, before we sign off here?
I don't think so. I would just, encourage people exactly as you did. So, no, I think this was a great show.
Yeah, I agree. We appreciate our audience staying with us through. It was a heavy show comparatively, but we want you to know, the world out there, it presents real dangers, but Aslan is always on the move. God maintains his outposts even in the darkest of places. So thank you for listening to us recap that and talk about it and encourage you about it on House to Home. The podcast, as always, a Family Policy Alliance Foundation. Alongside Grace Youngson, I've been Joseph Kohm. Thanks to Jonathan Keller for joining us earlier in the show. We will see everyone here next week on House to Home.